Hello, everyone. I am Anis
Hello.
Reddy, CEO and Chief Privacy Consultant of Privacy Pulse Consulting Incorporation. Welcome to another episode of Privacy Pulse podcast, where we explore data protection laws, privacy trends, and compliance framework shaping today's digital world. Today, we are heading to East Africa, to Kenya, a country renowned for its wildlife diversity. The country has a rich array of ecosystems supporting the biodiversity. While the country has taken remarkable measures preserving its wildlife heritage, it has also made remarkable progress protecting personal data privacy through its Data Protection Act 2019 and subsequent regulations. The Act established the Office of the Data Protection Commissioner, and over the years, Kenya has moved rapidly to implement privacy principles similar to global standards like GDPR, focusing on transparency, accountability, and lawful processing of personal data. To help us unpack Kenya's data protection journey, challenges, and its practical implementation, today we have with us Mr. Timothy Samson. Mr. Timothy is a seasoned data protection officer with expertise in data privacy, legal research, project management, and advocacy. He has served in healthcare, education, and financial sectors, offering strategic guidance on compliance with GDPR and Kenya's Data Protection Act. Welcome, Mr. Timothy.
Thank you.
How are you
Thank you so
today?
much.
How are you
Fine,
today?
thank you.
Good,
I'm
good,
good.
good, very good,
Having a
very
good morning.
good, very good. So, Mr. Timothy, let's
Yes.
start with the basics. For our listeners, could you please give us a quick overview of the Kenya Data Protection Act 2019 and what led to its introduction?
So the Data Protection Act 2019 came about because we have an Article 31 of the Constitution 2010, which stipulates about the right to privacy. We have Article 28 of the Constitution 2010, which stipulates about the right to dignity. So the Data Protection Act just came about to actualize the constitutional requirements for privacy and dignity. And therefore, it was just coming to buttress how we can enforce those rights, because previously we didn't have a law specifically governing personal data. And that is what the lawmakers crafting this law so that we ensure that we protect the right to privacy, personal data, and specifically dignity that comes with the privacy. And that was also in line with what was happening around the world, because Kenya moves with the world. And Europe was already having GDPR in 2018. And seeing the law moving towards personal data protection and privacy through GDPR, Kenya had to also go with the world where it was moving to in terms of protection of personal data. And that is how the Data Protection Act came about and created an independent Office of the Data Protection Commissioner to manage it. So briefly, that is what happened.
Okay, that's a very strong foundation, Mr. Timothy. How closely is Kenya's law aligned with the EU GDPR, which seems to be the global benchmark?
So just like I said, pointed out before, the Data Protection Act was aligned to GDPR. And the points of divergence are merely on things like fines. Kenyan's fines under the Data Protection Act for violations of data protection or breaches of personal data are a little bit lower, because we look at lower calculations compared to GDPR, which goes for higher calculations. And I think more of deterrent measures by giving higher penalties compared to Kenya. Having said that, what are the similarities? Kenya is aligned to the GDPR. Why am I arguing this way? If you look at the data subject rights, they are similar. Data subject rights, both under GDPR and under the Data Protection Act. You look at the principles of data protection, they are similar under the GDPR and under the Data Protection Act. If you look at the Office of the Data Protection Commissioner, it's both there under the GDPR and it's also there under the Data Protection Act.
Right.
So ideally, those kinds of fundamental spines that run through the document or threads that run through the documents are similar to what happens under the GDPR. And that is why I can confidently argue that the GDPR, the Data Protection Act of Kenya, is just similar or aligned to the EU GDPR in terms of protection of personal data of data subjects.
Right.
Yes.
Now, speaking of enforcement, which is a very necessity for any law to enforce it. Otherwise, any law is futile if there's no effective enforcement. So, how active has the ODPC been since the act came into effect?
Oh, if I remember so well, I think it was in 2023 where the ODPC made its first enforcement to Oppo Kenya, the telco called Oppo Kenya. There's a telecommunications company called Oppo. They sell phones. They also market phones. And ideally, they somehow used the photo of a data subject
I see.
illegally and unlawfully and
I
without
see.
consent to market themselves on Instagram, a social media site. And the data commissioner came out robustly and gave them a penalty of 5 million Kenya shillings. That was the first penalty from the Data Protection Commissioner in 2023.
Right.
The Data Protection Commission also came up with guidance notes on enforcement and handling of data protection grievances and cases. I can confidently say that in 2024, there were 34 enforcement cases that went through the Office of the Data Protection Commissioner. And most people get penalties for breaches. Most data controllers and processors get penalties for breaches. So, in terms of breathing life into the law, the Office of the Data Protection Commissioner has actively breathed life into the law of the Data Protection Act, and the enforcements that have been done or been given are evident for everybody to see. And having started with the ODPC enforcement of Oppo Kenya case, which I think you can also refer to. I can give you a citation if you want for future reference and readership. I think we can confidently say that so far, in the 5-year tenure of the Office of the Data Protection Commissioner, there have been more than 150 enforcements so far. And I can confirm the office is actively working in terms of enforcement. So there hasn't been any gridlock. If you don't want to go through the enforcement measures of the ODPC at times, you're always advised before by the ODPC. You can choose to go ADR, alternative dispute resolution, with a data subject who is complaining. Half of the time, some people opt for the ADR so as to protect the reputation of the company and probably the name being dragged in mud with those kinds of breaches. So ideally, the office of the ODPC is active in terms of enforcement measures for data breaches. That I can confirm.
That's really fascinating, and I think other jurisdictions should take a lesson from this type of enforcement, because if there is no enforcement, no law will be effective, whether it is
Exactly.
the civil law or it is criminal law or it is a data privacy law, whatever. There should be enforcement. Very good.
Yes.
And now, what will you say are the most common compliance challenges in Kenya for the organizations? What challenges are they facing?
Yes, for a new law, because I'll say this is a new law, it's 5 years old. Like
Yes.
every other country, with the challenges that come with a new law, civic education and awareness of the public is always a very big challenge. We always say ignorance of the law is no defense, but we must also defend the data subjects and even the controllers and processors if they don't know about this law. So it's upon the Data Protection Commissioner to go out and do civic education and create awareness. It's upon the data controllers and processors to go out vigilantly and embrace any new laws that have been gazetted. So awareness is the first challenge that we have with regard to that law. The
No doubt
second
about it.
challenge, yes, the second challenge that we have, I think, is the evolving laws and inadequate regulations, probably in
Yeah.
some sectors.
Right.
Most sectors need tailored, specific laws to govern
Right.
them. For
Right.
example,
Right.
health,
Right.
finance,
Right.
researchers,
Yes.
journalists. So the evolution of regulations that guide these sectors has been slow because, to the best of my knowledge, I think the first guidance notes came about in 2021. The most recent guidance note came about in 2024, last year, for journalists and researchers. The health guidance notes also came about around 2022. So there has been a slow and gradual evolution of laws, and I think that has hampered or hamstrung the implementation of some laws a bit from that end. The other challenge, which I think I also see, is at times there are weak penalties that are
Right.
awarded by the Data
Right.
Protection Commissioner
Right.
for the breaches. It's
Yes.
bad to have a law without a bite. The law
Right.
has to have a bite to be deterrent.
Right.
So if
I
the
agree.
law cannot deter any would-be abuser or breacher, then people would be always breaching the law because the penalties are just a kid's gloves on them.
Right.
So we are always imploring the data commissioner that we can enhance the laws to make them more deterrent and stronger. The other weakness which I think I spotted with regard to Data Protection Act is lack of adequacy decision by the EU. Kenya is still deemed a third country because we don't have the adequacy decision. Arguably, EU still argues that we still cannot protect personal data to their standards. So we are
Right.
still grappling with the challenge of the adequacy decision. I think those five would suffice for now in terms of the challenges we are facing as the Data Protection Act in Kenya.
Very informative, Mr. Timothy. Thank you so much. Now, let's talk about a subject or topic which is very, very common and heatedly debated among the professionals, which is cross-border data transfers. It's always a
Yes.
very hot topic. How does
Yes.
Kenya handle data being transferred outside the country? Could you please shed some light on it?
So I'll just make it very brief because
Yeah,
cross-border is a very deep and
very
wide
deep.
topic.
Right.
I started, like previously, the challenge I told you is we don't have an adequacy decision.
Right.
So not having an adequacy decision makes us a third country. It is a challenge for EU countries to trade with us because we are a third country. So how does Kenya operate? The ODPC has created an avenue where if you want to do cross-border data transfer, you conduct a DPIA 60 days before.
I see.
You submit the DPIA to the Data Protection Commissioner. The
Right.
Data Protection Commissioner will vet and gauge whether the country where you're transferring the data to is adequate enough to protect our data and is aligned to the global human rights policies that govern the world
Right.
before they approve of the transfer.
I see.
And that is mainly for mass transfer of data subjects, the crucial data, personal data. If it is for limited, for instance, a patient or a client wants to book a hotel in the EU, for instance, that we do what we call derogation contract. And
Right.
derogation contract may entail a consent of the data subject
Data subjects.
in terms of the transfer. Just have a contract, a data protection contract that aligns to our Data Protection Act and probably even the GDPR if you're going to a hotel in the EU, and surrender your data to the hotel there. Or you transfer your vital health data there for medication like telemedicine, for instance. And those are the mechanisms that now most Kenyan companies use for data transfer cross-border.
Right.
Just align your contract, have a contract, a data protection contract that is aligned to our Data Protection Act, have a derogation contract,
Right.
give your consent. And other than consent, give also another kind of reason besides consent, because consent is always very weak. And half of the time, most people withdraw consent. Vital interests, legitimate contracts, or for instance, contractual obligations that allow you to give the data. So ideally, that is what happens. And we have what we call the Malabo Convention in Africa. The Malabo Convention also allows for consent for cross-border transfer and allows intra-trade amongst African countries.